Good afternoon, everyone. I'm Ilsa Knecht, and I am the Deputy Director of Public Policy for the National Center for Victims of Crime. I want to welcome you to today's web seminar, Victims' Rights and Services During the Post-Conviction and Exoneration Process. I want to just go through a couple of housekeeping issues for those of you who are not familiar with the WebEx system. The slide is for people who are having trouble with their audio. It is coming over your computer speakers. So if you're having any issues, just turn on or adjust your speakers. If you have any technical issues regarding audio or any other issues, please call WebEx support at 866-229-3239. And I just want to let you know that today everybody who is on the webinar is in a listen-only mode, so you won't be able to ask questions verbally, but you will be able to ask questions using the question and answer panel. This is what the panel might look like. It's usually on the right side of your screen. It might be minimized, so you may have to click the little arrow next to it to maximize the screen or to open the box. Type your questions in the small box at the bottom and then hit send, and that makes sure that your questions get sent to us. Only the panelists see your questions, so the other presenters do not see those questions. We're going to do our best to answer all questions today at the end of the webinar. If we don't get to your question today, we'll follow up with you by email afterwards. I also want you to notice that the chat function is not enabled during the webinar, so if you need to reach us for anything, please use the question and answer tool. And I get this question a lot. You will not be able to see how many participants are on this webinar, so no, you are not the only person here. We do have about 63 people right now. We have quite a few more to log on. So you will only be able to use that question and answer function and see that for the duration of the webinar. You also may have noticed when you logged on that there is a poll we're taking at the right side also of your screen. You might have to maximize that as well. It says polling. That panel says polling. This is actually a sort of a pre-test that we take so that we can measure what you know before the webinar and what you know after, so we can measure the effectiveness of our trainings. And if you haven't gotten a chance to complete the poll, if you could do so soon, we'll close that in about a couple minutes as soon as our presenters start speaking. As well as the polling, don't forget to hit submit to send us your answers. I want to take a minute just to tell you a little bit about the National Center for Victims of Crime before I turn over the webinar to our presenters. Our mission is to forge a national commitment to help victims of crime rebuild their lives. We do this through direct support to all crime victims on our Crime Victim Helpline, 1-800-FYI-CALL, and through our website and email. Victims can get information about victims' compensation, safety planning, and their legal rights, among other support on that helpline. We provide training and technical assistance to those who work with victims, and we work with Congress to secure rights and resources for victims of crime through policy. We also are home to the National Stalking Resource Center and a teen youth initiative that focuses on teen victims of crime. Since about 2002, the National Center has been focusing on increasing understanding of forensic DNA and DNA technology among those who interact with victims. Our work has focused mainly on maximizing the potential of DNA technology because we understand that if we do maximize DNA technology, we can solve more cases, prevent more crimes, and bring answers to more survivors. We want to thank our funders, the Office for Victims of Crime, who support our work through a Recovery Act grant. Our goal with this project is to ensure that professionals who work with victims have the most up-to-date information about DNA so they may provide accurate guidance to victims whose cases involve DNA evidence. This webinar is the third in a series of 8 that are geared towards an audience of victims-serving professionals. Our next webinar will be on the collection of DNA in cases such as domestic violence, elder abuse, and child abuse. And future webinars will focus on the issue of missing persons and solving cold cases and working with victims in those cold cases. So stay tuned for announcements about those webinars. And I want to mention that we have also created a listserv for those who are interested in DNA-related issues. You can email me if you'd like to get onto that listserv. We've developed materials about forensic DNA for victims and professionals who work with victims. Those are on our website. And you will find news articles about DNA and interviews with professionals in the field and survivors who have important stories to tell about the power of DNA. All of those are on our website. Here's our website here, www.ncvc.org/DNA. And my contact information is here if you want to email me to get onto the DNA listserv, or if you have any DNA-related questions. We have a sort of an advisory panel of professionals in the field that we can send DNA questions to, so feel free to reach out to us if you have any questions. Okay, so now we are going to hear from our first speaker. We have two wonderful speakers with us today. We are lucky to have them. Our first speaker is Meg Garvin. Meg Garvin is recognized as a leading expert on victims' rights. She is the executive director of the National Crime Victim Law Institute and a clinical professor of law at Lewis and Clark Law School. In these roles, she leads NCVLI's National Impact Litigation and Legal Technical Assistance programs. She regularly presents on victims' rights and participates in national forums to develop policy on victims' rights. She has testified before Congress and the Oregon legislature on the current state of victim law, and she co-chairs the Oregon Attorney General's Crime Victims' Rights Task Force. She is also a member of the board of directors for the National Organization of Victim Assistance. Our second speaker is Chris Jenkins. Chris has worked at the Dallas County District Attorney's Office for the past 20 years, 13 of those as the Victim Witness Coordinator. She is a founding member of the Crime Victims Council of Dallas County. Chris received the Practitioner Award from the Texas Crime Victim Clearinghouse in 2004. She has presented for many agencies and organizations, including the Crime Victim Clearinghouse, the Texas Attorney General, the Texas Crime Victims Institute, the Texas District and County Attorneys Association, and the Dallas County Sheriff's Academy, and as well as the National Center for Victims of Crime. So today we are going to start with Meg Garvin, and I'm going to hand the floor over to Meg. And see if we can get Meg here. Here we go. We'll start with you, Meg. Now you have the floor.
Great. Thank you so much. I am really excited about both today's presentation, and I'm grateful to be able to present, but also about this whole series of trainings that NCVC is doing. The issue of DNA and victims' rights is an emerging one that I think the field really needs to pay more attention to. So the leadership of NCVC on this is very much appreciated, and I'm excited to be a part of it. So what I want to start with is tell you what I will cover today. I'm going to cover a little bit of Victims' Rights 101. I will not go into too much depth, but I just want to get everyone on the call or on the webinar on the same page generally with victims' rights. Then talk a little bit about what rights attach post-conviction and really what post-conviction looks like. What are the different iterations of post-conviction? And then looking at the rights that attach post-conviction, look at and see what they can really look like from a victim's perspective. And I'm just going to use a couple of cases as examples to point out the hurdles for victims when it comes to exercising rights post-conviction. And then I'm going to talk about what's missing in the processes, the current victims services processes to make victims' rights truly meaningful post-conviction. And I'm just going to touch on these, but I think Chris, our second presenter, she has amazing expertise and experience that I think will help provide some promising practices. So I'm going to leave a lot of that discussion to her, and I'm just going to highlight a few points. So with that, let's go ahead and get started with Victims' Rights 101. As everyone on the call, I'm sure, is aware, being a victim of crime is really a process in many ways. There is a clear line of demarcation that starts your victimhood, and that is the act of criminality that impacted you, and that's a really clear starting point. But the reality is that there's no end to your victimization, in that it's a process of healing and a process that lasts throughout your life. And anything that interrupts that process, that creates a new roadblock or a new bump, impacts you. And DNA is certainly one of those interruptions in the process of healing. And there's good and bad with DNA from a victim's perspective, right? As NCVC has demonstrated, through other avenues and trainings and educating the field, DNA can help solve so many crimes, it can help prevent crimes, but also when it comes to post-conviction, it leads to a lot of uncertainty for victims about what happened. In rape cases, the credibility of the victim is challenged all over again. They weren't believed the first time. Now they're being told that maybe if it's an exoneration, they're not being believed again. So there's a lot of roadblocks and hurdles that come with DNA and post-conviction that make the process even harder. And so what victims' rights can do in the post-conviction context is help make that disruption the least painful as possible. So what are victims' rights generally? Well, victims' rights generally, wonderfully, we have gone from passing legislation 30 years ago, 35 years ago, to a place now in the most recent decade to where victims' rights are being recognized as enforceable rights. And what I mean by that is we've passed the statutes in every jurisdiction. 30-plus states have passed constitutional amendments affording victims' rights to notice, information, privacy, participation, and in the last 10 years, the enforceability of those rights has come to be relatively well recognized. And when I say enforceability, what I mean is that the victim gets to ask for those rights. They get to say, I want to be present during trial. And if that is denied, the enforcement moment is they get to go to the appellate court and ask for it and hopefully have it enforced. So we have come to this place wonderfully where, at least in a daily practice, victims are recognized to have rights during the criminal investigation and prosecution, and in many jurisdictions, the enforcement of those rights, meaning that there's some sort of remedy if they're denied, is starting to take root. And that's tremendous progress. But the interesting thing is that this is pre-trial and sometimes at trial. The recognition of victims' rights post-trial, and more importantly, post-conviction, is not quite as secure. And we all know, if we go back to thinking about victimization and being a victim as a process, the case or the victimization is not over at verdict. We know there is a lot that happens post-verdict, and we need to figure out what do rights look like post-verdict. Now, there are certainly some commonly recognized rights that are post-trial rights. So post-trial, we know that there is the right to be heard at sentencing. That is another one in Victims' Rights 101 that is pretty well accepted. In fact, this is one of the rights that the United States Supreme Court has had the most to say about. We know back in 1991 that the U.S. Supreme Court in Payne versus Tennessee acknowledged that victims have a right to be heard at sentencing through a victim impact statement, and that that right does not infringe upon a defendant's Eighth Amendment right. So we know that we have that right. We know that there is a right to restitution, and depending on what part of the process you all work in, we know that there's a huge difference between the right to restitution and the collection of restitution, but generally speaking, across this country, it is well recognized that post-trial there's the right to restitution. We also know that in most jurisdictions, there is some level of right to be heard by a parole board if parole exists in your jurisdiction. What that right actually looks like in practice varies tremendously, and there's a lot going on to make sure that it's not a de minimis right and that victims are actually afforded notice and a true opportunity to be heard. But generally speaking, these are pretty well accepted that you can be heard by a parole board in some form. So we have some commonly recognized post-trial rights. But that still leaves this gap where the victims field has not yet secured a place for victims, at least not as solidly as it has in the pre-trial and immediate post-trial moments, and those are post-conviction. So generally speaking, there are three avenues to challenge a conviction. There's direct appeal, there's state collateral review, which is often known in many jurisdictions as post-conviction or a post-conviction review, PCR, and then there's habeas corpus review generally through the federal court. So these are three avenues by which a defendant can challenge his or her conviction on any number of grounds. And what's interesting is that 43 states have explicitly provided laws governing DNA testing for defendants during these processes. So we have states that explicitly allow for and set forth the processes by which a defendant can access DNA testing and challenge it. And, you know, their procedural processes, how they go about it, what they do, what court they present it to. The other 7 states generally have either case law or something else that sets out how a defendant can challenge it. So the question becomes, do victims have rights during these also, and where do we find those rights? The answer is that yes, victims in almost every jurisdiction have some rights during these proceedings, and sometimes, though, it's an argument. We have to go find the right, because what hasn't happened yet is the idea that it's a, for those of you who've heard me present before I use this term a lot, we haven't reached the point where it's a no-duh. It's not a no-duh yet that victims are a part of post-conviction processes. And if we go back to my theme, which is that the victim recovering from a crime and healing is a process that doesn't have an end, we absolutely have to figure out how to make it a no-duh, that victims are part of post-conviction proceedings also. So where could we find rights for those jurisdictions that have them, or where can we find models or best practices so that jurisdictions that don't have it can look to promising practices? Well, in the federal system, wonderfully, the Federal Crime Victims' Rights Act, which was passed in 2004 and was initially silent about post-conviction proceedings, in particular habeas, was amended in 2006 to provide explicit protections to victims of crime in habeas corpus proceedings, which are challenges of state convictions going through the federal system. And so what rights do victims have explicitly under the federal CVRA? They have the right to not be excluded from public court proceedings. And I'm going to talk in a few minutes about what that looks like and what a public court proceeding might mean. They have the right to be reasonably heard at any public proceeding. And again, we're talking habeas here. They have the right to proceedings free from unreasonable delay, and they have the right to be treated with fairness and with respect for the victim's dignity and privacy. Now, that last one is a very broad right that when we're looking at federal proceedings, habeas proceedings, we can use to protect victims in a number of ways. Now, what is not explicitly set forth in the Federal Crime Victims' Rights Act when it comes to habeas rights for victims is what I think is actually the gateway right or the foundational right, and that is notice. The Federal Crime Victims' Rights Act does have notice of proceedings in its list of rights that attach to other proceedings, but not to the habeas. But that silence should not be interpreted as a lack of right. Federal due process law, when we look at United States Supreme Court precedent and federal appellate court precedent from around the country, makes clear that due process of law requires notice. So if you ever have a right that is going to be implicated by a proceeding, you must have notice that that proceeding is going to happen. So while the federal CVRA does not explicitly provide that victims of crime should have notice of habeas proceedings, arguably they should, and I think if we actually litigate that issue, which is something that NCVLI does around the country, we would, you can never promise as a lawyer that you would win, but I would say that we should win that one, that we should have notice. So in the federal system, at least with federal habeas, we have a number of explicit rights. So what about states? Because I know from the attendee list that we have folks from all different jurisdictions. Well, the rights really do vary. At least 12 states provide directly that victims should be notified of DNA testing results and the related proceedings. What is meant by related proceedings in each of the jurisdictions varies a little bit, and what is meant by notified of testing and testing results varies a little bit. But we have at least 12 states that have started to grapple with this. We also have Oregon, which is my home state here, where NCVLI is based, that just this past spring passed House Bill 3634. And I apologize to anyone on the line who's a lawyer who wants the perfect site. I could not find where it had been codified most recently, but this is the bill that passed, and I'm certainly happy to find the codified version for anyone who wants it. But what Oregon did is it started to look at best practices around the country, and it passed a bill that has explicit rights for victims in post-conviction proceedings, and those are the right to be notified of their rights, which is in most jurisdictions actually considered the right to be informed, the right to reasonable, accurate, and timely notice of, that's a typo, I apologize, of appeal, post-conviction, or federal court action. So Oregon made it explicit that the rights attach to any of the three-tiered aspects, to attend any public hearing related to these proceedings, to be reasonably protected from the offender if the offender is present. That attachment of if the offender is present is an interesting narrowing that if one looks at best practices in the country would not necessarily be something you'd want in your law. To have your schedule taken into account during scheduling of post-conviction proceedings, to be heard at certain hearings, to consult with the state's attorney on the case, and to be informed of the outcome of proceedings. These are, Oregon, like I said, took best practices from around the country and tried to craft a statute that provided the most comprehensive list of rights that explicitly attach post-conviction. As I said just a few minutes ago, 12 other states have laws that deal in some aspect with DNA and post-conviction. But what we shouldn't forget is even if there is silence in your jurisdiction about victims' rights post-conviction, many states in their general victims' rights statutes or constitutional amendments have a provision that says something to the effect of victims have the right to dignity, fairness, and respect, or some iteration of those broad rights. And then there's a tagline attached to that right that in most jurisdictions says throughout the criminal justice process. In litigation, we can use the throughout criminal justice process to say that the rights continue post-conviction. So we can try to use the broad rights of crime victims that attach throughout the criminal justice process to say that victims have to be afforded some rights post-conviction. That's an argument that when it comes to enforcing a victim's rights, NCVLI and its clinics that are located in 12 jurisdictions with support from the Office for Victims of Crime, we have been able to start 12 pro bono legal clinics around the country. That argument is something that those attorneys who provide free legal representation to victims would make, but I think it's something to remember when we're talking about best practices for victims post-conviction that we would want to be thinking about, making sure we don't forget those. So what we have are explicit rights in habeas in the federal system. We have a handful of states that have some explicit right, and I've given you Oregon that has a list of explicit rights. And then we also have the broad right of dignity, fairness, and respect throughout the criminal justice process. So then it comes down to where the rubber hits the road. What might these rights look like when we're talking about post-conviction? And what are the gaps in the rights? I'm going to just go through a couple of them and give you a few cases so that you can see what courts are starting to grapple with when it comes to DNA being challenged. And the reason I give you the 3 levels of post-conviction is a defendant has those 3 levels to challenge his or her conviction. And so those are the moments when challenging of evidence, DNA, comes in, either to say the DNA that was collected and tested and said I did it as defendant was done in error, or to say please give me the right to test more DNA because I didn't get to do it. Those are, generally speaking, the 3 avenues it comes in at. So the right to be heard. Want to give you a case on this. This case just came down on July 19th of this year, and it's a very interesting case where some co-victims of homicide, so the survivors, actually on their own without legal representation filed papers with the federal court asking for their rights in the proceeding. It was a homicide case. And the court went through a long process to say you can't intervene in this case, you're not a party to the case. But what the court did say is it addressed the Federal Crime Victims' Rights Act right to be heard. And the court, I'm going to go ahead and read from the case because I think the court did some interesting things. The court talked about, under the CVRA, victims have the right to be heard. The court stated that that attaches to habeas corpus proceedings. And then the court said, we have to deal with this. Is this issue of, is this a public court proceeding? If you remember from the language that I had up on the screen a few minutes ago, the rights only attach to public proceedings or public court proceedings. And what the court said is this. It says the parties disagree about whether the court's considerations of a habeas case in chambers constitutes a public proceeding. The court agrees with the applicants, which are the victims of the crime, that such is the case. Court records in habeas proceedings are generally accessible to the public. Most habeas cases are resolved on the pleadings without in-court hearings. And this is the important part. To preclude crime victims from submitting documents to the court in support of their right to be heard in a habeas proceeding would effectively preclude them from being heard in almost all cases. The court thus concludes that the applicants, as crime victims, have a right to be heard under the CVRA in this habeas proceeding, and therefore will accept their documents. That's a really important moment, because what the court said is just because this is being done on the papers, which is how most DNA challenges happen and most post-conviction things happen, doesn't mean that the victim doesn't get to be heard. They can file papers also. And so the question is, what might they file papers on? What do they have the right to be heard about? That can vary case by case. You know, they can want to be heard about their privacy interests. I'm going to talk about that in a minute, about what DNA testing does to them. They can be heard about speedy disposition. I'm going to give another case example about that. But what this Pan case, Pan v. Warren, said is you do get to be heard even though these post-conviction things happen on the papers. So that's a very important case that just issued. So then, proceedings free from unreasonable delay. Anyone who has had to work with victims in any post-conviction setting knows that the process is interminably long, really. And then we have the DNA testing component coming in, and even though on the papers, meaning the papers that a defendant files with the court, he or she says, you know, I really need this testing and I want it now, the reality is actually the DNA testing often delays proceedings even longer. So under the Federal Crime Victims' Rights Act and many of these state statutes that I've mentioned, victims have the right to proceedings free from unreasonable delay. And so what does that look like? The case I have on the screen right now is the Douglas Stewart Carter v. I can't say Clint Friel's last name. I don't know the warden's last name. This is a 1985 first-degree murder case that resulted in a death sentence. And in May of 2009, so remember, murder in 1985, May of 2009, the defendant is still seeking DNA testing. And in May of 2009, the defendant files papers with the court saying, hey, give me till June to tell you what the status is. So he's asking for just another month or two to give status update on the DNA testing. In June of 2010, an entire year later, still nothing has happened. And so we have both the fears and anxiety that come up when DNA testing is happening for victims, as well as delay. And what happened in this case is in June of 2010, wonderfully, one of the clinics funded through the grant that I mentioned already from the Office for Victims of Crime to NCBLI, one of our clinics, the Maryland Crime Victim Resource Center, filed papers in this habeas case saying that the victim has a right to proceedings free from unreasonable delay and that the defendant cannot have an open-ended calendar in which to do DNA testing. And the defendant came back and said, you can't rush DNA testing, you can't, you know, do all of these things. And what the court just did within the last month was say, I agree with the victim. The victim does have this right, and so I'm going to issue a scheduling order that mandates that the defendant make progress on DNA testing and demonstrate what steps are being taken. And we're going to have a calendar in place for this post-conviction proceeding that says what has to happen. So the victim here, again, thinking back to the first case, the Pan case, had the right to be heard by filing these papers, and then was able to assert the right to proceedings free from unreasonable delay so that the defendant did not have, you know, the next 20 years to do DNA testing. Still is getting the DNA testing, but doesn't have in perpetuity to do it, which is very important for victims as they move through the process. So then the next case I want to highlight is one that was at the U.S. Supreme Court in 2009. And I have it flagged for fairness, dignity, and respect, as the rights that attach, but sadly, in my opinion, the United States Supreme Court did not expressly address the victimization issues in this case and focus squarely on the defendant's rights, even though NCVLI filed an amicus brief that was joined by the survivor in this case. This was a rape case. KG was a woman who was raped at gunpoint in 1993, and she was left for dead. She was shot and left for dead. In 2008, so again, remember 1993 is the rape, and in 2008, the defendant is still fighting for DNA. Despite the fact that he has not signed an affidavit of innocence, he is asking for DNA. And what he is asking for, I want to flag this for everyone, because what this case points out is the privacy implications for victims when it comes to DNA. What the defendant, whose name was Osborne, was proposing to do was test not only the condom that was found at the scene, but he wanted to also test KG's clothing as well as get DNA testing from her, the blood that was extracted from her and others, to figure out everyone who was involved. Now, if you look at it just from defendant's standpoint, you might think, well, that would say, you know, it could prove he was not the person that did it, or at least potentially exclude his semen. But if you look at it from the victim's standpoint, you think about the reality of what you can get from a DNA test from a victim, and when you start looking at what might be on her clothing, these DNA tests implicate her privacy interests because other partners' DNA might be on her. Her own blood sample might reveal things about herself that she doesn't want known publicly. So there is a lot at issue in DNA testing. And so what happened in the Osborne case is very interesting, and it's something for the field to be aware of. The action was brought as a Section 1983 civil rights claim. And if you remember back to what I was saying earlier, there's 3 ways to challenge your conviction, right? There's direct appeal, state post-conviction or PCR, and federal habeas. In none of those 3 sentences or phrases did I say Section 1983. And yet, Osborne brought a Section 1983 action saying, I want DNA testing. So what is important for the field to know, and what NCVLI did in its amicus in this case, was say, we did not oppose defendant getting DNA testing. What we said is defendants have to use the processes in place in those 3 traditional ways of challenging a conviction, because it's to those ways of challenging a conviction, direct appeal, PCR, and habeas, that victims' rights attach. And by going through a 1983 action, Osborne essentially end-ran all the victims' rights protections. And so all these privacy considerations that KG had, she wouldn't be able to be heard on. If we go back to Pan and the other case I just mentioned, the filing of papers and being heard, if you're allowed to do DNA testing through a 1983 action, you wouldn't be able to be heard. The victim would be left outside again. So kind of the 1970s version of victims' rights, which was you were a piece of evidence not to be heard from. That's where we would be. So the Osborne case stands for the premise that we need to go through habeas to make sure victims' rights attach. And Osborne did not answer the question, but the field should know, you all should know that there's a case, Skinner v. Switzer, which is actually up the U.S. Supreme Court right now. They just granted cert, that is actually asking this exact same question. Can DNA testing be accessed through a Section 1983, or does it have to go through habeas? And the field should consider that victims' rights right now only attach to habeas, and so to be most protective of victims, we really want to be looking at making sure the court comes down on the side of habeas. So the last right I wanted to flag is the right to be present, and right now there are no cases out there that have yet talked about it, but I wanted to flag it because while most of the proceedings happen on paper, there are hearings, evidentiary hearings that happen through all 3 of those avenues, direct appeal, post-conviction, and habeas, that result in actual hearings happen. And victims may want to know of those hearings and be present. And as victim service providers, You know, victims want a lot of different things. Sometimes they want to know about things, sometimes they don't. Sometimes they want to be present, sometimes they don't. At some of these evidentiary hearings, there may be DNA experts testifying about what they found and what it means. And when we think about the process of healing for victims, sometimes knowledge is what they need. And to have the opportunity to hear from an expert about DNA may be something that is useful to them. And so securing the right to be present, even if it's through alternative means of presence, closed circuit TV, conference call, whatever it is at some of these post-conviction proceedings may be really important. So I just have two more points really, or two more slides. What is the foundation of all of these rights? From a victim-centric perspective, I've given you kind of the lay of the land in terms of the law, and I think there's a lot of work to be done on making sure that we have best practices in every jurisdiction. But the punchline is there has to be choice for victims about all their rights, the choice to knowingly and voluntarily assert their rights or waive their rights, whether that be pre-trial, during trial, or post-trial, including post-conviction. And what choice requires is notice. So I mentioned this earlier, that notice is really the gateway for all of these rights. And without either of those, without notice, there can be no choice for victims, and then we are subjecting them to re-victimization. So some victim-centered considerations with regard to notice and choice should be on your radar when you're setting up your policies and procedures in your own jurisdictions, as well as looking at whether your jurisdiction has the best law that's in place, or whether there are model laws from elsewhere that should be considered. So notice, when should a victim be noticed? Should they be notified when testing happens? Should they be notified just of the outcome of testing? Those are important considerations, and they're things that we need to ask of individual victims. Individual victims want different things, and we have to start asking them. How should we notify them? This really matters. It comes up in different iterations. When it comes to exonerations, we really want to make sure that if an exoneration actually happens, that there is some in-person notification, hopefully by a victim advocate being present. We need to be thinking about how can we achieve that, and what about notification? Who should be doing it when it's just the possibility of exoneration, meaning DNA is being tested, but we don't know what the outcome is going to be yet. We need to make sure that that notification is happening by someone who's educated in DNA, as well as educated in the realities of what the standards are for challenging a conviction. Consideration of opt-in and opt-out. I don't know if Chris is going to talk about this a little bit, but we need to consider best practices about talking to victims at the beginning of proceedings, meaning trial level. We should be talking to victims about this. Do you want to be notified of post-conviction proceedings? To what degree? When? And then always allowing them an opt-out at some point. Some victims may at some point say, I cannot hear about this anymore. I do not want to hear about this anymore. And that can be okay. That should be their choice. Then we need to consider what services come after notice, meaning after notice that DNA testing is happening. Victims are going to go through a lot of trauma in that moment, a lot of trauma about what are the possibilities, and we need to think about making sure services continue through that moment. And then what services come after testing? Regardless of the outcome of the testing, either confirmation that the DNA belonged to the offender or an outcome that says that the DNA did not belong to that offender. And then what are the realities of that outcome? We need to make sure services continue. And then there are many other considerations, and I know Chris is going to talk about some of those as applied. But I think these are the things that as the field looks at its services and its rights, we need to pose these questions to ourselves. So I'm going to wrap up there. I put up on the screen some contact information for myself and for NCVLI. What NCVLI does, as I mentioned a couple times, we provide help connect victims with free lawyers around the country to help enforce their rights, but we also provide technical assistance to anyone. We'll do the legal research for you on issues, and we also help identify best practices. So feel free to contact me personally or NCVLI at the website, and we would love to stay involved in this issue with any of you in your jurisdictions, as I really do think this is an area that all of us need to become more educated about so we can do better by victims. So with that, I will turn it back over, as I know Chris has a ton of applied knowledge that she wants to share with us. So thank you.
Thank you so much, Meg. That was really wonderful information, very thorough, and I'm sure you'll probably get quite a few emails. People are already asking for the notes and the PowerPoint. So we will be putting those on our website sometime in the middle of the week next week. So you can check our website for those PowerPoint notes. And now we have Chris, and let me get her PowerPoint up for her and get her set up here. Okay, Chris, looks like you have the floor now.
Thanks, Elsa. I appreciate it. And I appreciate you asking me to present today. I frankly have learned a lot already just from Meg's presentation. I am going to bring it down to the Texas level. I'm not a specialist in Texas law by any means. I'm just a victim witness coordinator. But my job is to assist victims in Dallas County, and that includes these victims on these DNA exonerations. And at one point, I believe we led the nation in DNA exonerations, so I probably got a little bit more experience working with these victims than some of the other people throughout the nation. So this is just a compilation of some of the things that we have discovered that are important to the victims. In other words, things to be considered when you are deciding how you're going to handle these cases in your own office. It starts with Chapter 64 in Texas law, and we're going to discuss Chapter 64 and DNA victim issues. In Chapter 64, which was passed in 2001, it created a right for convicted criminals to obtain DNA testing of evidence related to their cases, a right to counsel for the purpose of obtaining testing, and a right to appeal the rulings related to their requests. So even if they are initially denied the right to DNA testing, they can appeal it, okay? And that's going to be important further down. Chapter 4 requires two things. Number one, that identity is an issue in the case. Now, when I first wrote this slide, that was the issue, but apparently it has been changed. It used to be the victim and the offender had to be strangers. In other words, it used to be a stranger-on-stranger crime. But they have changed the code, and I pulled it, and I'm going to read to you just real briefly what it says. It is irrelevant to the defendant's motion for DNA testing that the victim knew and identified the victim as her attacker, and that the defendant pled guilty because the defendant can identify an issue by showing that exculpatory DNA test would prove his innocence, even though he may have conceded the identity issue in trial. So even if he writes a confession, says I did it, and it's a family member, he can still ask for DNA testing. Okay. The other issue that he has to show is that in all likelihood the DNA results would show that he did not commit the crime. Several limitations on this include, of course, evidence must exist. If there is nothing to test, then there's no reason to even entertain this any further. The chain of custody must be good. It must have been possessed by the state at the time of the trial. In other words, it can't be new evidence that's come forward 20 years later. It's got to be DNA evidence that was available at the time. As Meg pointed out, it can't be used as a delay tactic. They can't use this to postpone it indefinitely. And the defendant cannot be at fault for lack of prior testing. In other words, it was available at the time of the trial. They didn't have it tested. Then that doesn't give him grounds for requesting DNA testing now. Now, just a couple of questions. Were you aware that a defendant can obtain post-conviction DNA testing even if he pled guilty, even if he confessed or made an admission of guilt? Now, the court cannot deny testing solely on his basis of pleading guilty or his confession, but they can consider it. But I can't tell you how many have come through where they have pled guilty. In regarding victim issues, like I said, these are some of the things that we have found and discovered are important to victims, and so I'm not telling you this is what should be done or should not be done. I'm just telling you these are the things we have found in Texas or in Dallas County, that are important, especially to the victims. Number one, establish a protocol as soon as possible. Decide all these things ahead of time if it's possible. The reason I say this is because we've had victims notified in different ways, and we found out through the months and years now the best ways to do it, okay? Should the victim be notified? If so, when? Okay, we have several cases where, let's say, the defendant asked for DNA testing, but it shows he did not commit the crime. I'm sorry, it shows he did commit the crime. Do you then notify the victim? Do they have the right to know? There are some people who say, no, don't put the victim through that if there's no need. But then there are others who say, absolutely notify that victim, because that victim then has the right to turn around and write a protest letter to the parole board stating, this person asked for DNA testing knowing that he victimized me 20 years ago in this sexual assault. So we're kind of denying the victim one of their rights if we don't notify them. The other side of that coin is you're re-victimizing them. You're putting this through this crime all over again. And so we have to kind of weigh it out. You have to weigh it out and decide what's going to be best for your victims, because they're all individual. They're all different. Number one, okay, notify when testing is requested or when it's agreed or when it's ordered. So are you going to notify this victim when the offender sends in a request for DNA testing? It doesn't make much sense to do that because, first of all, you don't know that there is evidence to test. So we usually wait till after we verify that there is evidence to test before we notify them. Do you notify them when you've agreed to testing? That's another point. We can agree, but first we have to find out if there's evidence to test. So basically what we usually do is notify them when we've agreed and when we find that there is evidence to test. And then you tell them, yes, we have agreed. Or do you notify them after it's already been ordered? These things may seem minor. However, if you have a victim that is registered with your local prison system to be notified if that offender is moved, let's say back to Dallas County for any kind, on a bench warrant for any kind of parole proceeding or appeal proceeding, that victim's going to call you and they're going to say, why was he brought back here? Okay, you have to be able to give them a reason. You don't want them to find out from the prison system that the person was brought here. You want them to find out from you first. And I say this because it happened with one of our victims. She called me and she said, Chris, why was he brought here? And I couldn't find it in my system. I had to go talk with our appellate division, and they told me, yeah, they've agreed to testing. She wasn't notified of that. That's how she found out, was through being notified by the prison system that he was brought here on a bench warrant. So you want to try to be the first one to tell the victim, if at all possible. Okay, another consideration is whether or not the victim was notified of their rights at the time of the crime. Now remember, in most states 20, 25 years ago, there wasn't anything in place to notify victims of their rights. They didn't have these rights. So our job now is to notify these victims from crimes 20, 25 years ago what their rights are now. So maybe at the time they didn't know they had these rights, but they're staying, let's say they're staying online and they're keeping up with what their rights are. And we've got a lot of them that do, a lot of them that don't. But if they do, you want to be the one that lets them know they have a right to be kept informed of appellate proceedings and a right to protest parole with parole board. Now, appellate proceedings are the ones Meg was talking about. We notify them on both the local, state, and national level. So in other words, when a decision comes down, we're notifying the victims of all of those. The parole board is their right to protest parole. A lot of these victims, as I said, are keeping up with these offenders. Every year they're finding out when they're coming up. They want to make sure they're there to protest it. Some of them are not. So that's just some of the things you have to consider. Have they been notified of these rights? Now, understanding victims' needs is important because, like I said, they're all individual, they're all different, they all do not need the same things. But you don't know that going into it, okay? You need to understand that some victims want to be informed of absolutely everything. And I mean everything. We had one victim who came in with 10 pages of questions. She needed answers, and that was the best way for her to get them, was to bring in those 10 pages, and we did our best to answer her questions. Now, we also have victims who don't want to be notified at all. One poor woman was called and notified that he had requested testing. Did she want to be informed of the results? She said no. And not only no, don't ever call me again. Excuse me, she said, hell no. Do not ever contact me again. So she still doesn't know the results of the tests. She did not want to have anything to do with this. It just brought it all back to her, and she wasn't ready to go back to that place again. The victims also have a need for confidentiality, especially in the older cases. Many, many of these victims, as you know, have gone on. They've married, have children, new jobs, new friends, and they don't know that they were victimized 25 years ago. So we have to be aware of this when you're, first of all, trying to contact your victim. Try not to leave messages on their phone like, this is the district attorney's office. We need to talk to you about your, sexual assault 25 years ago. Try to be very, very sensitive to their needs now, okay? We have an investigator that, when at all possible, he'll try to reach them at their work, or if nothing else, he'll go to their home and leave just like his calling card on their front door and just say, please give me a call when you can. Anything to not draw attention to a prior victimization is especially helpful to the victim. Be aware that victims need answers and they need help and understanding. So, like I said, some of them may come in with 10 pages worth of questions. Just be prepared to be patient and try and help them get as many answers as they need. They don't all need the same number of answers. Don't forget the victim when the evidence verifies that the offender did commit the crime. Let them know of their right to send a protest letter. Let them know that we're going to send a protest letter to the parole board, letting them know. Also, let them know at the hearing, we'll read a statement for them if they want to come face that offender, because he is brought to the court and he does have to face the judge. At that hearing where they tell him, your evidence verifies that you did commit this crime, we let this victim have the right to come in and speak, or if they want to write a letter, we'll read that letter for them, whatever they feel comfortable doing. And it's not the same with all of them, like I said. What can you do? Provide as many answers as possible. Timelines. How long is this testing going to take? Why can he ask for this testing 20 years after the crime? What's the process of this DNA testing? What can the possible outcomes be? Provide as many answers up front as you can. That's the best thing you can give your victims right now. Help them understand the limitations of the judicial process. Once they find out that it was not the true offender that they thought it was, why can't the true offender be tried? That's, of course, the statute of limitations, and that's the number one question that comes up with victims every day. It's the number one frustration with victims every day. In Dallas County, we developed a brochure to help explain the process and answer as many of these questions as possible. Plus, we also gave them a list of resources in the area for counseling and whatever they feel like they need, where they might need to go for answers. So if any of you would like a copy of that brochure, I'd be happy to email it to you or send it to you. My contact information is at the end of this presentation, so feel free to contact me and I'll be happy to send it to you. Some of the other things to consider are sending protest letters to the parole division, like I said, when it verifies that the offender really did commit the crime, because they are re-victimizing this victim for no reason. Encourage your victim to write protest letters, both when it shows that they did commit the crime and when it shows they did not commit the crime. These victims, in turn, can now send protest letters on the true offender. Okay? So we've got protest letters when they did commit the crime and not, because now the victim has a new offender that they have to keep track of and try and keep in there as long as possible. Let them know, okay, this person was not convicted of my crime, but DNA shows he did commit it. We can't try him for that crime, but DNA shows he did commit it. So you need to be aware of that when you're considering him for parole. Now, in our office, we also send a letter to the parole division informing them of the true offender's established guilt in an additional crime. So not only do we encourage the victim to write a letter, we also send one. And it's a strongly worded letter stating this person asked for testing knowing he committed this crime. We re-victimized this victim, put them through this all over again, and there was no need. Or this person was victimized 20 years ago. We're just finding out the person she thought committed the crime did not. We need you to know this other person did commit the crime, even though he did, it does not show that he did commit the crime. Give the victims a voice. Allow them to speak or have a statement read at the exoneration or confirmation hearings. And I underlined "or" because this is important, not only the confirmation hearings, but at the exonerations. We had one victim who was not able to attend the hearing, but she wanted to have a letter read. I'm afraid it was a little bit too strongly worded, and so my superiors would not let me read it, but it was given to the judge. So the judge did get to hear her statement, her feelings, how strongly she felt about what was going on with her case. Some of the other things you can do are help strive for policy change. The victims really, really have a hard time understanding that. Why are there no repercussions for bad faith DNA requests? Why can we not convict the true offender? Remember, your victims are going to be the best speakers on this topic. We have one victim in particular who is doing everything she can to get the statute of limitations waived because it makes no sense to her that DNA that was available back then can be used to set the incorrect offender free, but it cannot be used to convict the true offender, which is one of the problems, of course, we're experiencing here in Dallas County. Statute of limitations won't let it happen. So she's working for change, and I applaud her completely. More power to her. She's a strong person. She can take on the legal system like I can't. Some of the things you might want to consider is to be creative. Be sensitive to your victim's need for confidentiality by meeting at a location other than the home or work. We had one of our investigators who actually met with one of the victims. She lived out of the state. He flew to the local airport where she lived. He met her at the security office at the airport. He took her buccal swab at the airport, and he met her there during her lunch hour. So no one at home and no one at work knew that she was coming down to give us a buccal swab. Coincidentally, it turned out that the offender did commit the crime, so she was victimized needlessly, but at least her confidentiality was protected. Now, with another victim, we provided a picture of the defendant or the exoneree. Actually, we gave her a picture of both past and present, because during her trial with the offender who was subsequently released, he turned around and he looked her in the eyes and he said, "I'm going to get out of here and I'm going to kill you. Excuse my expletive, but this is what he said, I'm going to kill you, bitch." So she's lived with this threat for 20 years, this fear that he's going to get out and come after her. So when she found out DNA showed he did not commit the crime, she was scared to death. So we gave her these pictures of the offender, both past and present, to give to her local police department and give to her children. So if they saw him, they could notify the police. This was just for her own safety and her own well-being. She was just deathly afraid he was going to come find her. One of the things we also did in Dallas County was form a support group for victims in DNA exonerations. It was the main focus of this was because there's no one else who knows what they're going through. Other sexual assault victims are not experiencing the same thing these DNA exoneree victims are. It's just not the same. So they're the only ones who can identify. You might want to also consider, when you are being creative, is provide What we did in one case for one victim is we let her hear an audio tape of his confession. In other words, the true offender, knowing the statute of limitations had run, he allowed us to videotape his audiotape his confession. We let the victim hear it, and then she was convinced, yes, this was the person, because you got to understand, not every victim is going to believe you. I have a good 4 or 5 victims who are still convinced the true offender was set free, that the DNA tests were contaminated, and that there is no way this person did not commit the crime. So what we do is do everything we can to try and help convince them. And then at that point, you just have to say, I'm sorry. If you don't agree, let's get you some counseling. And it may seem harsh, but there are, in some cases, just nothing we can do. Like I said, remember, not all of them are going to understand or agree with the results of the DNA testing. Many are going to feel let down by the legal system and especially by the prosecuting attorney's office. Our job here in the DA's office is to help victims understand that their rights are still important and have not been ignored or forgotten. So just get creative, understand that everyone's different. There is no right or wrong way to work with these victims. Just be open to their needs. And I'll turn it over to you, Elsa. Thank you very much. I appreciate it.
Thanks so much, Chris. We don't have actually much time, and in fact, we don't have many questions. I think we'll try to answer them by email. So I want to thank you both for your presentations. I think I definitely learned a lot, and I will be watching the recording to catch what I didn't catch the first time. So just to let everybody know that the presentation was recorded. It will be made available in an on-demand format. You will be able to get the link on our website. Probably won't have that up there till possibly midweek next week, but go ahead and check our website. That's the www.ncvc.org/DNA. We'll also we will send you an email with the information about when the recording and the PowerPoints will be loaded onto our website. So also remember to visit that website to learn about the future webinars. And we have a poll going right now. If you can answer that poll for us. We're going to go ahead and log off, but the poll will stay up for a few minutes. And if you can answer that, that's, again, the second part to our test that helps us measure how effective our presentation was today. So thanks again to both of our speakers, and we hope to see you on one of our next webinars. Have a good afternoon.